Welcome to this audio post of our blog series. This edition is entitled Defending the Algorithm, a Bayesian Approach. My name is Henry Sneath, and I'm your narrator. I will also provide some commentary outside of the written text. I'm a business trial lawyer in Pittsburgh, Pennsylvania, and I specialize in patent, trademark, copyright, trade secrets, and other intellectual property and AI-related business litigation. Defending the Algorithm is the title of a series that I've developed for blogs, podcasts, and video, hopefully down the road. We will be joined from time to time by guest authors, and we will welcome them to this post. I edited this installment, and it was authored with assistance from Claude AI by Anthropic Sonnet Edition 4.5 Pro, and some research verification by Google Gemini AI 2.5 Flash. Claude and Gemini can make mistakes, so please double-check this content if you intend to rely on it. Here's our introduction. Our previous analysis of the historic $1.5 billion Anthropic settlement in Bartz v. Anthropic revealed how Judge Alsup's groundbreaking ruling established a potential bright-line legal framework distinguishing between permissible AI training on legally obtained copyright works and impermissible use of pirated materials. While this decision provides initial crucial guidance to legal practitioners on copyright fair use in AI training, it represents only the opening chapter in a rapidly expanding legal battleground over how AI's companies acquire and use their training data and how companies deploy AI enterprise software in the delivery of products and services. You can see my prior post on the Bartz v. Anthropic case at our website, which is www.hh-law.com. Here's Chapter 1, the Bayesian Analysis. AI and the law are at a critical intersection, and lawyers should be prepared to counsel business clients on the front end of AI integration into their business structure and on the back end when litigation arises. What is the probability that AI issues will become a core or major part of litigation in the future? How will the AI and superintelligence frontier technology affect the legal issues in IP, patent, copyright, and trade secret law, technology and cybersecurity law, environmental and energy law, employment law, and renewable energy, land use, and zoning law? It will likely impact all of these substantive areas of the law, and Bayes' theorem, just as it plays a role in AI, can assist us in evaluating the probability of this becoming reality in the practice of law. The Bayesian approach guides us to number one, accept the Judge Alsup, Northern District of California, Bartz v. Anthropic opinion, and his ruling on Anthropic's LLM training as our prior probability or baseline assumption. Number two, combine it with new evidence from other cases and forums to create a likelihood function. And three, apply Bayes' theorem to arrive at a posterior probability predicting how likely the Alsup opinion will be to become established precedent across multiple federal circuits. Bayes' theorem of probability originated in the 1700s when Thomas Bayes, who was a British statistician, philosopher, and Presbyterian minister, created his theorem, which was later published by friends and colleagues. His theorem is a fundamental building block in the probability predicting technology of AI and the race to create AGI, artificial general intelligence, and the new buzzword, superintelligence. It is useful here to develop an understanding of how we can use the theorem to predict new developments in the law of AI. Let's apply an AI principle to the evaluation of AI and the law. Let's use AI concepts to evaluate AI and the law. With this understanding, we can then try to predict the likelihood of lawsuits being brought against businesses that use AI enterprise software, are training LLMs, or are using AI to make important business decisions that impact other businesses, customers, and employees. Bayesian analysis allows us to update probability estimates as new evidence emerges. So let's set up and then dissect the AI and the law equation to examine this probability analysis. For those listening and not reading this post, I will be reading mathematical equations and will try to put the terms and symbols into spoken language. So forgive me if I stumble in these descriptions. When I wrote this on paper, it looked marvelous. When I decided to read it, I realized that reading math equations is not only difficult, but hard to listen to. So please stick with me, and I hope that it all comes together for you when I am done. The important thing is we want to understand AI and how it works, and we want to apply the same probability prediction theory to our projections about where the law of AI will go in the future. So here is the equation. The probability of AI litigation given certain types of business operations equals the probability of business operations given AI litigation multiplied by the probability of AI litigations divided by the probability of business operations. That was a math equation, but with words relating to AI litigation and business operations. The terms that I were referring to are written in an equation as the letter P, which is probability of. AI litigation is defined here as lawsuits by or against companies which involve AI issues. Business operations is defined as the information related to how a business uses AI. And the word given is represented by an up and down straight line that would be on your computer keyboard. And given means a conditional probability. In other words, the probability of something occurring in the future, given what other evidence we already know to exist, what other circumstances exist which may impact that probability. That's the essence of the Bayes theorem. And for those of you taking notes, Bayes is B-A-Y-E-S, Thomas Bayes. So breaking down each component of the equation, the definitions of the stages in the process of the analysis are the following. The posterior, I talked about the posterior probability, is what we want to test. Here, the probability of AI litigation given certain business operations. That's the posterior probability that we want. Likelihood is the pattern recognition from existing cases. This is what AI does. It recognizes patterns. And we as lawyers have to look at patterns in litigation to determine where litigation will go in the future, and therefore how do we counsel clients on avoiding that litigation or on bringing that litigation when it's to their benefit. Prior means the baseline risk. It assumes certain underlying statistics. That's part of the equation. And evidence is how common your activity is. In other words, what we're calculating here are how we recognize patterns. Here's our starting assumption. Here's a common business or legal situation. Here it is in more detail. The probability of AI litigation given business operations equals the posterior probability. This is what we're solving for. The probability that a company will face AI litigation given its specific business and AI operations. This is the updated risk assessment after considering new evidence like the Anthropic settlement and other cases. The probability of business operations given AI litigation equals the likelihood component of the equation. This asks a business who is worried about AI legal risk Among companies that have faced AI litigation, what percentage had AI business operations similar to yours? As an example, these are not real statistics, if 80% of companies that were sued for AI copyright infringement in a relevant time period were using large language models for training or content generation, then the probability of content generation given AI copyright suits would be 80%. So you create an 80% likelihood that that company will get sued for copyright infringement. The probability of AI litigation is the prior probability. This is the baseline probability of AI litigation across all businesses, regardless of specific operations. It's a starting point. An example, again, not real statistics. Before the Anthropic case, it could be estimated at 5% of tech companies facing AI related lawsuits. After Anthropic, which is new evidence, updated to 12% probability as litigation increases. In other words, at the essence of Bayes is taking a baseline probability, assuming new facts, and coming up with a posterior probability. In the middle of that is the Anthropic suit and others that I'll discuss shortly. All of those go into the mix of evidence and go into the estimation of future probability. Probability of business operations, the evidence. This is the probability that any randomly selected business engages in your business's specific AI related or LLM operations. Example, again, not real statistics, the probability of using LLMs for content might be 25% of businesses now using LLM tools. Those statistics are or can become available as more and more people focus on this area. So we can use those statistics to build the probability analysis. The point here is that this probability analysis is at the ground floor, but is part of a rapidly developing analysis in the legal profession. The Bayesian analysis is a good way to guide our thinking about the probability of increasing AI-related litigation, and it helps us understand the foundational principles of AI itself. While we predict that AI litigation will rapidly increase as AI becomes ubiquitous in business, healthcare, insurance, and most companies, we are not yet in a position to accurately predict the probability of any one company getting sued for its use of AI, unless we can determine that the company is training LLMs or is using AI enterprise software in a way that has already resulted in similar companies getting sued for similar AI use. It's part of a lawyer's job to advise companies on their risk of litigation, and you can only do that by looking at a probability analysis based on existing law and on business operations. Hence the equation that I talked about above. We are only at the very beginning of the development of AI law, but we are getting more data all the time, which will give us better and better ability to predict the posterior probability referenced above. Beyond the copyright issues addressed in BARTS, a new wave of litigation challenges the fundamental methods by which AI companies harvest the massive data sets that fuel modern large language models, and by which companies use AI enterprise software to power their business operations, to make business and human resource decisions, and to deliver products and services. These emerging cases move beyond traditional copyright infringement theories to explore contract violations, unauthorized access claims, DTSA trade secret claims, employment claims, and systematic data scraping disputes that may prove more resistant to the fair use defenses that benefited Anthropic, at least in parts, in the BARTS case. This is chapter 2. The quote AI and the law, end quote, evolution beyond copyright. New legal theories emerge. Well, Judge Alsup's transformative use analysis in Bartz v. Anthropic established that training AI on legally acquired copyrighted works may constitute fair use. Plaintiffs' attorneys are rapidly developing alternative legal framework that sidestep copyright's fair use protections entirely. The probability of AI lawsuits being based on claims other than copyright infringement equals high. That was a math equation. Here's some examples of other types of claims that we're seeing. Claims brought under term of service violation umbrella. In Reddit versus Anthropic, which is at docket number 3:25-CV-5643 in the Northern District of California, Reddit alleges that Anthropic has systematically been scraping data from Reddit's massive trove of Reddit user data and posts in Reddit communities and in subreddit spaces. The complaint focuses on whether Anthropic violated the Reddit website terms of service when systematically scraping training data. Anthropic admits that it has scraped data from Reddit and other sources to train its Claude LLM, which of course assists me in writing these blogs. Unlike copyright claims, these contract-based theories don't face the same transformative use challenges that benefited Anthropic under Judge Alsup's four-factor fair use analysis. Website terms of service typically include explicit prohibitions against automated data collection, creating potential breach of contract claims that exist independently of any copyright consideration. Reddit's legal strategy in this case seeks to avoid a fair use by Anthropic, which provided them with a defense in the Bartz case, and which has complicated these copyright cases. Here's another example, the Federal Computer Fraud and Abuse Act, the CFAA. Plaintiffs are increasingly pursuing unauthorized computer access claims under the CFAA, arguing that data scraping constitutes unauthorized access to computer systems, regardless of whether the scraped content itself enjoys copyright protection. This federal statute provides potential criminal and civil liability for accessing computers without authorization, creating a pathway around copyright's fair use doctrine. It's a complicated statute, and we will explore the CFAA in greater detail in the future as the scraping cases move further along on CFAA theories. Unjust enrichment and quasi-contract claims. These theories focus on AI companies profiting from data they obtained without permission or compensation, creating quasi-contractual obligations to pay for the value received. Unlike copyright infringement, unjust enrichment claims don't require proving ownership of specific intellectual property rights. Reddit brings these claims in its case against Anthropic, which I just discussed. This is Chapter 3, Data Scraping and Terms of Service, a legal framework distinct from copyright. Systematic data scraping presents unique legal challenges that distinguish it from the straightforward copyrighted issues addressed in Judge Alsup's Bartz ruling. When AI companies deploy automated systems to harvest data from websites, social media platforms, or proprietary databases, they potentially violate multiple legal principles simultaneously, none of which depend on copyright ownership. In Ryanair versus Booking.com, the District Court of Delaware, in a 2024 decision, held Booking.com liable under the CFAA for screen or data scraping of Ryanair data from the Ryanair reservations website. My prior blog post on that case is on our website. Examples of some more likely legal theories in the future. Contract law implications. Most commercial websites include terms of service that explicitly prohibit automated data collection from those sites, bot access, or systematic downloading from their site. Even when the underlying content lacks copyright protection, violating these contractual terms potentially creates independent liability. Federal courts have generally enforced such terms, particularly when data scraping interferes with website functionality or violates clearly stated access restrictions. Unlike the copyright fair use analysis that saved Anthropic from liability for legitimately acquired books, contract violations typically don't enjoy any fair use type defenses. Another potential claim, trespass to chattels. This traditional common law theory applies when automated scraping consumes server resources, degrades website performance, or interferes with normal operations. The claim focuses entirely on the method of data acquisition by the scraping entity rather than the nature of the content itself. Server overload, bandwidth consumption, or interference with legitimate users can establish liability regardless of copyright status. In other words, if the scraping entity in training an LLM, for example, pulls data from a website and it affects the function of the website, this can give rise to a claim. State law privacy and right of publicity claims. When training data includes personal information, biometric data, or individually identifiable content, which it does in the Reddit database, AI companies may face state law privacy violations that operate independently of federal copyright protections. California's robust privacy framework, for example, provides potential claims that don't depend on copyright ownership. This is Chapter 4, Enterprise AI, Upstream Liability in the Training Data Supply Chain. The distinction between copyright infringement and data acquisition violations creates significant implications for companies deploying enterprise AI solutions. This is when a company obtains an AI solution from another company and builds it into its business model. Well, Judge Alsup ruling in Bartz v. Anthropic provides comfort that using AI-trained or copyrighted works may be permissible under fair use. It offers no protection against claims that the training data was improperly acquired through pirated sites, contract violations, or unauthorized access. The probability, therefore, of lawsuits based on business use of AI's enterprise software equals high. Examples of some of the new risks facing AI using businesses. Upstream liability risks. Companies implementing enterprise AI platforms like NVIDIA AI Enterprise, Google's Vertex AI, or Microsoft's Azure OpenAI service may face liability for training data acquisition methods they neither chose nor control. If the underlying AI models, which are built into a company's business model through enterprise software, were trained on improperly scraped data that violated terms of service or CFAA provisions, enterprise customers could face claims even if their specific deployment would qualify for copyright fair use under the Bartz precedent. An indemnification gap analysis. Standard enterprise software licenses often limit vendor liability and may not cover claims related to training data acquisition methods. The Bartz settlement demonstrates that training data liability can reach billions of dollars, yet many enterprise AI contracts provide limited indemnification coverage. Companies should carefully review vendor agreements to understand whether they're protected against upstream data scraping claims that fall outside copyright law. Due diligence evolution. As training data litigation expands beyond copyright, companies may need to conduct enhanced due diligence on AI vendors' data acquisition practices. In other words, be careful what you buy. This evaluation should extend beyond copyright compliance to examine terms of service violations, CFAA risks, and privacy law adherence, areas not addressed by the BART's rulings fair use framework. This is Chapter 5. Trade secret law per the DTSA intersects with AI legal issues. The Federal Defend Trade Secrets Act, DTSA, which is part of the Federal Economic Espionage Act, the EEA, is a powerful statute which was enacted in 2016 and which provides both criminal sanctions against a misappropriator of trade secrets and civil liability damages and penalties against those found civilly liable to a trade secret owner for misappropriation. The intersection of AI training and enterprise AI data litigation with trade secret law under the DTSA creates additional complexity that extends well beyond the copyright issues resolved in the BART's case. While Judge Alsup's ruling addressed copyright fair use, it provides no guidance on trade secret misappropriation claims. DTSA claims will undoubtedly be brought with regard to AI data collection or scraping of proprietary business information. Therefore, the probability of DTSA lawsuits relating to AI equal very high. Here's some examples of why this probability is very high. Proprietary database protection. Compiled databases, customer lists, pricing information, and proprietary data sets often qualify for trade secret protection when they provide a competitive advantage and have been reasonably protected by the trade secret owner. AI companies that scrape such protected information may face DTSA claims that operate independently of any copyright considerations. Unlike copyright's fair use doctrine, trade secret law provides no general fair use defense. Trade secret owners, however, must be ever more careful to protect their trade secrets when they upload data to the cloud or AI platforms. This trade secret conundrum works in both directions. I will write more on this in future posts, but suffice it to say now that anytime you place proprietary business information into a cloud product or an AI platform, you risk it losing trade secret protection because it's not secret from the whole world. Discovery's black box problem. Trade secret claims in training data cases create the same algorithmic transparency challenges we've identified in insurance and bad faith AI litigation, like the case Estate of Locken versus United Health Group. That's Locken, L-O-K-K-E-N. I've also written about that case on our website. Courts must balance the plaintiff's need to understand how their proprietary data was acquired and used by, say, United Health Group, against defendants' interest, that's United Health Group's interest, in protecting their own trade secrets around training methodologies and algorithmic implementations. Insurance carriers are increasingly using AI enterprise software to underwrite insurance policies, to make claims decisions, and to evaluate healthcare claims, like in the Locken case. This pretends that insurance carriers will continue to see a growing number of breach of contract claims and bad faith lawsuits regarding their claims decision being done by bots. Therefore, the probability of insurance lawsuits based on AI use is very high. Cross-border complexity. Many training data sets include information scraped from international sources, potentially implicating foreign trade secret laws, data protection like GDPR in Europe, and cross-border discovery challenges that didn't arise in the domestic copyright issues addressed in BART's. Chapter 6. Strategic Defense Evolution in AI Claims and the Need for Businesses to be Proactive. The expansion beyond copyright to breach of contract, unauthorized access, and trade secret claims requires defense strategies that address multiple legal theories simultaneously, a more complex challenge than the copyright-focused analysis that proved successful for Anthropic. Here are some examples of these challenges. Multi-vector documentation by businesses. This simply means better documentation and proof of how a company collects data. While the Bart's case emphasized the importance of legally acquiring copyrighted works, companies now need comprehensive documentation covering terms of service compliance, automated access protocols, rate limiting measures, and respect for robots.txt files. Technical logs showing respectful scraping practices may provide defenses against trespass and CFA claims if a lawsuit arises. In other words, companies need to be more careful in documenting how they are obtaining data and information. Licensing strategy evolution. This means proactive licensing by businesses of data from its owner. The trend toward post-training licensing agreements exemplified by Anthropic's settlement may not cure initial contract violations or unauthorized access claims. Proactive licensing arrangements become increasingly critical when legal theories extend beyond copyright's retroactive fair use protections. Companies need to consider licensing before collecting massive data and getting sued. In other words, if you pay for it up front, you won't likely get sued if you download it correctly. Vendor risk management. This means that businesses must conduct robust due diligence, like investigating where an AI enterprise vendor got its training data for the software that you intend to purchase from that vendor. Companies using AI enterprise software programs must implement supply chain due diligence that evaluates training data, acquisition methods across all applicable legal frameworks, and not just copyright compliance. This includes reviewing vendor practices for terms of service adherence, CFAA compliance, and trade secret protection. Therefore, the probability for the need of businesses to be far more proactive in ensuring legal collection of data is high. Chapter 7, Looking Forward, the Multi-Theory Training Data Defense Framework. Judge Alsop's favorable fair use ruling in Bart's v. Anthropic represents a significant partial victory for AI development, but it addresses only one component of an increasingly complex legal landscape. As training data and AI enterprise litigation evolve beyond copyright, companies need comprehensive strategy that account for the full spectrum of potential legal theories against them, or on their own behalf if their business information has been violated. In other words, the lawsuits can go in both directions, and companies need to be prepared for either situation. Here's some examples of these strategies. Integrated risk assessment. Legal analysis must simultaneously evaluate, inter alia, copyright fair use, contract compliance, unauthorized access risks, trade secret exposure, tort claims for unfair competition and tortious interference, and privacy law adherence. The Bart's precedent provides copyright protection but leaves other legal vulnerabilities unaddressed. Supply chain liability planning. The enterprise AI ecosystem creates potential liability chains extending from training data acquisition through final deployment. Companies must understand and plan for potential liability arising from upstream vendor practices that may violate non-copyright legal requirements. Evolving compliance standards. As courts develop precedents around acceptable data acquisition practices across multiple legal frameworks, compliance requirements will continue evolving beyond the copyright considerations addressed in Bart's. The bright line rule against using pirated materials may expand to encompass other forms of improper data acquisition. Companies need, therefore, to evolve. The next phase for lawyers who are defending the algorithm requires understanding that AI legal challenges extend far beyond the copyright framework established in Bart's v. Anthropic. While Anthropic's settlement demonstrates that fair use may protect AI training on legally acquired copyrighted works, it provides no shelter against the expanding universe of contract, unauthorized access, tort claims, and trade secret claims that challenge the fundamental data acquisition methods enabling modern AI systems. Companies that prepare for this broader legal landscape, encompassing not just copyright, but the entire ecosystem of laws governing data acquisition and use, will be better positioned to navigate the complex intersection of technological innovation and legal compliance in the AI era. We will explore these new legal theories in upcoming posts. Here's a Bayesian conclusion. The probability of increasing litigation based on the behavior of the AI ecosystem equal very high. Well, that's all for today. Look for future posts and audio presentations at www.hh-law.com. My thanks to Claude for its assistance with defending the algorithm series. Houston Harbaugh's AI and intellectual property team in Pittsburgh will continue to monitor developments in AI and the law. For questions about how these changes may affect your business or creative work, please contact me in our office at my email address, sneathm@hh-law.com, or by phone to my office, 412-288-4013. Thanks very much for listening, and we'll see you next time.